Good afternoon. I want to thank everyone for joining us today. My name is Lindsey McKay, and I'm the owner and lead advisor at McKay Wealth Management. And one of the things that we frequently do for our clients is provide educational webinars. And so we look to provide information that's sort of around their financial lives, things that they need to be doing in order to support the work that we do with them for financial planning. And a big part of that is estate planning. It's one of the areas that we find that people are hesitant to dig into the most. It tends to be something that we wait for the future to deal with, but we're going to talk today about the importance of getting started early and making sure that you have your plans in place. For those of you that are joining a webinar for us for the first time, it is a listen-only mode. There is a feature for question and answers in the bottom middle of your screen. So Andrew Lee, who's an advisor in my office, is joining us today, and he's going to be facilitating any questions that come about. Our expert that we have with us today is Jerrica Pierson Seeger, and she's an estate planning attorney. She's going to encourage you to ask questions as you go, so do not be shy. Jerrica is joining us from Des Moines Elder Law. She specializes in estate planning, probate, and actually has some expertise in veterans benefits as well. So I'll let Jerrica give a little bit more information about herself as we get started here. But I wanted to start by thanking her for joining us today, and thank all of you for taking the time to listen in and learn a little bit more about estate planning. With that, Jerrica, I'll send it over to you.
Well, thank you so much, Ms. Lindsey and the whole McKay team for letting me participate in today's presentation. Like Lindsey alluded to, I think questions throughout the presentation are really valuable. If you're thinking about a question, lots of time other participants are as well. So Andrew will be monitoring your questions, and I'll stop throughout the presentation to try to address them as they come in. Thank you so much for your time today, and I look forward to helping you navigate this space as we go through the presentation. So basically what we're talking about today is just getting the basics done. And when we talk about the basics of estate planning, we're really talking about answering 4 primary questions. Okay, and we're going to go through each of those questions today. So here's our roadmap. We're going to go through the 4 questions. We're going to talk about how you can get those questions completed and addressed, how each type of plan can become effective, or how it is authorized or used when an event occurs, and then some of the more complex planning needs that would really drive an individual to seek specialized guidance. So, step 1 in our roadmap. What are the 4 questions that typically get addressed in our traditional estate planning package? So the first question is, who inherits what when you pass away? So that concept not only applies between married couples, but also individuals who are transferring assets to heirs, beneficiaries, or other people who are going to inherit from their estate. That set of documents is called a testamentary document, meaning a document that is effective upon someone's passing. The second question that gets addressed is the question related to who is your decision maker in the event you are unable to make decisions and need someone to be making those decisions for you, either due to incapacity or disappearance or other disabling conditions that make it difficult for you to be able to make your own decisions. Those documents are called agency documents. The third question that gets addressed when you complete an estate plan is the document that tells your advocates what are your wishes for end-of-life care. So if, whether it's in the medical industry or in-home care or your family members, what are your wishes for certain conditions, certain types of medical interventions? And the final document, the final question that gets addressed in an estate plan is, what do you want to have happen to your body once you've passed away? So we're going to go through some of the details for all 4 of those. Okay, going back to question number 1, who inherits what when you pass away? There are lots of ways to accomplish this task. The 2 most common that people hear about all the time is called a will, or a last will and testament. And the alternative to a last will and testament is called a revocable living trust. Both of these documents accomplish 2 things. 1, they identify who you name to do the work associated with your estate. If you have a will, that person is called a personal representative. Sometimes they're called executors. If you have a revocable living trust, that person is called your trustee. We're going to talk in a minute about the difference between a will and a trust. But some of the other tools that may be less common that also accomplish this goal of who inherits what when you pass away. One is called a community property agreement. This is an agreement that married couples can use to avoid probate and transfer assets to the surviving spouse following the first spouse's passing. Now, I know everyone is thinking, well, if I'm a married couple, I definitely want that. And whether or not you want to have a community property agreement is really very case specific. And just because we're in Washington State doesn't mean you have to have one. The other way that you can transfer assets, as you may be aware, is through titling. So this would be if you have joint accounts, joint ownership will transfer to the survivor joint owner at passing. Beneficiary designations, these are really common on life insurance and retirement accounts. When you create that asset, you're prompted to identify a beneficiary, and that identified beneficiary is actually a contractual commitment between you and the financial institution that when you pass away, the person you've named will inherit the asset. The final way that if you don't do any planning and you pass away with assets in your name, Washington State has what is called intestacy rules. This means these are rules that dictate where money goes if someone hasn't otherwise provided for where their money goes in a plan. Intestacy rules follow the general parameters of a nucleus family. So if you are married and your spouse passes away, the majority of the estate will go to your surviving spouse. If you don't have a surviving spouse, it will go in even shares to your children. If you don't have children, it will go to your parents. If you don't have parents, it will go to your surviving siblings. If you don't have surviving siblings, it will go to your nieces and nephews. And it follows that pedigree chart line until there is no other individual, and then it will sheet to the state. If you have children from prior marriages, second marriages, disabled beneficiaries, charitable wishes, the intestacy rules will not provide for your intent. So that may be a reason in itself to get some planning done. Now, there's always lifetime gifting. So if you choose to transfer assets while you're alive, obviously those assets are part of your estate at passing, but that is another way to get money to a beneficiary. Andrew, is there any questions thus far on those questions on those slides so far?
Yeah, one question on if you could elaborate on when you would want a community property agreement and when you don't need one. I'm guessing that might be coming up later, but it came up, so I wanted to ask.
Perfect. So community property agreements are a document that Washingtonian married couples can use as a probate avoidance tool. So they provide for the constructive transfer of marital assets, community assets, when the first spouse dies to the surviving spouse. They also identify to Washington State that you want your assets qualified as community property. There's a presumption in Washington State that married couples, all the marital assets that was earned or acquired during a marriage is presumed to be community property, but you don't have to comply with that presumption. So we find that married couples who have all their assets were earned or acquired during marriage, and it is their goal that at their passing, all assets transferred to their surviving spouse, that is the ideal time to use a community property agreement. However, if you have children from a prior marriage, if you have separate assets, if you had an inheritance that you want to maintain a separate classification for, or if you have a taxable estate and you need to do tax planning when the first spouse passes away, those are situations where you may not want a community property agreement. I hope that answered that. To get into more detail related to whether a married couple should have a community property agreement, I would advise seeking legal counsel, because there are situations that with a community property agreement, a married couple may be giving up certain estate planning based goals that you don't want to do. So going on with the difference between a trust and a will, we talked about this being something we're going to talk about. A revocable living trust is an alternative to a will-based plan. The revocable living trust has a couple of benefits that many clients like. It is a probate avoidance tool. Now, what is probate? Probate is a required process for a will-based plan to become effective. So if you were to choose a will-based plan and you passed away, in order for the banks or title companies to know what a deceased person's wishes are, they can't just accept the will and do what the will says, because the banks don't have any evidence that the will that's being given to them is the legit last created will of the person who passed away. So that's what probate does. Probate proves up the will so that it is established as the last will and testament. And the provisions in that document control where the assets are supposed to go. So that's why banks and title companies rely on the probate process to ensure that the assets are going where they're supposed to be going. A revocable living trust-based plan does not require a probate if it is funded appropriately, because a trust owns the assets, the deceased person does not. And that's the big difference. Because the trust owns the assets, the provisions that control that asset are dictated under the terms of the trust. In that way, there is some argument to be made that it is an easier process for your trustees and the people that you've named to do the work in the event of your passing, or to manage your assets in the event of your incapacity, because you've done the work to put all the assets in the trust while you're still alive. So to the extent that your wishes are to make it as easy as possible for your family members or the people that you've named to help administer your estate, there is some truth to the trust being an easier document for that administration. However, that ease comes at a cost. It is more difficult for you to set it up. It is more work for you while you're living and creating this plan to make the trust fully funded and make it operate the way it's intended to operate. It also costs a little bit more to set up. So you are doing more work it's harder and a longer process for you as the person creating the trust, and it costs more money. But in exchange, it will be less burdensome on the people that you've named to step up at your passing or at your incapacity. It also avoids probate, which means there's fewer attorney fees, usually fewer processes post-death for your beneficiaries to receive their share of the estate. So a will-based plan, like I've alluded to slightly, is a post-death only. So that means it's not effective. You don't do anything with it until you've passed away. And then your executor, or the person you've named as your personal representative, will usually have to go to probate in order to get that will validated. There's a process through probate. In some states, probate is really arduous and very expensive. That is not true in Washington State. Our system is pretty efficient. There's not required PR fees. So most people in Washington end up with a will as their primary planning tool. Because a will is only effective at your passing, there's no lifetime protection. So for people who have concerns about protecting their assets from their own future vulnerabilities, a trust has some benefits there that a will does not. Okay, Andrew, this is usually a couple slides that draws a number of questions. Is there anything that's popped up before we go on to our next set of documents?
Yeah, it's like you've given this talk once or twice before. A point of clarification, does probate kick in with the passing of a spouse in the example of the community property agreement, or would one still need to go via the probate process and the execution of the will?
So the community property, if a married couple has executed a community property agreement before the first spouse dies, so this is something you would have to sign before either spouse has passed away. When the first spouse passes away, the community property agreement has to be filed. There's also an affidavit that has to be effected. So even though it's a probate avoidance tool, there's still a little bit of work that the surviving spouse needs to do in order to constructively have all of the assets transferred to the surviving spouse's sole name. It's pretty modest amount of work, so it's pretty efficient to get done, but there is still some work to be done. If you have a community property agreement, you do not need probate, because probate is only needed if we have to prove up the terms of the will to know who inherits the assets. A community property agreement tells us who inherits the assets. It's the surviving spouse. So because we can utilize a community property agreement, if a married couple has effected one, we will not have to do probate at the first spouse's death. There are a couple of exceptions, so never say never. There are a couple of exceptions if there's a wrongful death suit or other liability lawsuits. Sometimes a probate may be required, but that has to do with lawsuit claims, not necessarily estate administration. So don't quote me if you think I said never or always. I never or always say anything. But if a married couple or an individual who's transferring assets to other persons who's not married, if they have a will, the way probate gets started is that generally the personal representative will bring the original will and the death certificate to the attorney that they choose to work with. And that attorney will help them prepare paperwork to open the probate through the courts. There is generally some delay between when a person passes away and when probate is opened. One of the positive ramifications of COVID is that process has actually, in many counties, been expedited because we no longer have to go to court to process this paperwork. So it can happen pretty quickly, but there is still some level of delay, usually between 4 to 6 weeks from the date someone passes away to the date that probate is opened. Once probate is opened, the personal representative gets a document called letters testamentary. That document is kind of like fairy godmother's magic wand. It is the document that you provide to the banks or the title company or the insurance company to start the process of gathering up the assets of the deceased person. So we get letters testamentary because the courts have appointed and sort of ordained the personal representative named in the will, or the petitioner, to be the authorized person to manage the deceased person's estate. Good question.
That was great. Thank you. Yeah. And then one other. So, okay, let's say I love this. I've gone through, I've created a trust. How do I know what assets to go into the trust? How do I go about putting the assets into the trust? What comes next?
Great. So that is the toughest part of a trust-based plan. It's called the trust funding phase. So definitely you would want all of the real property that a person owns to be titled in the trust. That's kind of the easy picking. So your primary residence, if you own a vacation home, if you have timeshares, those things generally are funded into the trust, because that's how you can avoid probate. The other things that you want generally funded into the trust are brokerage accounts, other investment accounts that are not IRAs or annuities. IRAs, annuities, and other tax preferential accounts, we want to tackle on an individual basis. Those tend to not go into the trust, mostly because the IRS says that if you do that, there's negative tax consequences. And some annuity contracts have lifetime benefits that you would lose if you put it in a trust. So when we get to that level of funding, we're tackling each type of account individually to determine what the best strategy is. If you're getting a trust simply for probate avoidance tools, and you don't want any of the other benefits associated with a living trust, then maybe your funding is really about the key assets, the real property, and brokerage accounts. If, however, your goal is to protect your money from your future vulnerabilities, then funding it completely with other assets, savings, potentially smaller checking, vehicles, all of that can become more important, because the purpose of a trust is twofold. It's one, to manage post-death, and two, to manage incapacity during lifetime. So if you want that incapacity during lifetime benefit, you have to have your assets in the trust. Now, the next slide, which is going to talk about agency documents. One of the most common agency documents is called a power of attorney. So if you're concerned about the incapacity planning and you like the trust for that, but we can't put your retirement accounts in it, well, that's why you're still going to need a power of attorney, because a power of attorney is the document that is going to help manage those retirement assets, even if you have a trust as your base for your plan. So agency documents are the documents that address the second question in a traditional estate planning package, which is who's going to be the decision maker in the event of your incapacity. So if you have a trust, like we were just talking about, your trust has a trustee that you've identified to manage your trust assets if you become incapacitated. That's an agency relationship. So if you have a trust, you will have a trustee, and that trustee will be have a fiduciary obligation to manage your trust according to the terms of the trust document. If you have a will-based plan and a trust-based plan, you will also need a power of attorney for financial management. And that's because you have assets in your personal name. And if their assets are in your personal name, you need to have identified to the world who you trust to manage those decisions if you could not do so. Now, powers of attorney documents are state-based creatures, meaning that the federal government does not have a power of attorney statute. So if you receive benefits from federal programs, which is the Social Security, that kind of goes for everybody. But if you have a federal pension, a railroad pension, other pensions or financial assets that come from the federal government, the federal government agency is not going to honor a power of attorney. So for those agencies, each agency has created a representative payee process. So if somebody has incapacity and a change needs to be made on their Social Security benefit or their VA benefit or their military retirement or federal pension, in order for the person identified in the power of attorney to make those changes, generally, we are finding that the federal agencies are requiring that individual go through the representative payee process. I say generally because every now and then we find that they will accept a power of attorney, but more often than not, it will be a secondary process in order for that agent to manage the federal financial assets. Now, just like in your estate plan, if you've chosen to not do any planning, or the planning that you do is ineffective, the courts and the state of Washington have decided a process to create that agency relationship. It's called a conservatorship or a guardianship. A conservator guardianship process is when an individual does not have agency documents already created and a decision must be made on their behalf. So the courts get involved and they will identify an individual who will be authorized under the provisions of the court to make decisions on that individual's behalf. Sometimes that is the family member who petitions for conservatorship or guardianship. Sometimes it's professional guardians. Now, a lot of people are saying, well, we're in the community property state, can't my spouse, don't they have automatic rights to make decisions? And the answer is no. For financial decisions, there is no automatic decision maker under the statute. For medical decisions, the hospitals and medical providers do have an avenue under the statute to create a healthcare surrogate decision maker if there's not a power of attorney in place. So if there has to be medical decision made, the statute controls who has priority to do that. And just like intestacy rules, it follows the nucleus family dynamics. So if the individual that you trust to make your medical decisions is not part of your family, or you have family members you would not want to be involved in the decision related to your medical care, this is a good reason to consider getting a medical power of attorney, because you would not want the state statutes to come in and supersede your wishes. Okay, Andrew, we're about to go into the next step. Is there any questions?
Yeah, two questions. One, going back a little bit to the last slide, what if you have a transfer on death clause in your will or on an investment account? Would those still need to go through probate?
So I think if I repeat back the question, it's if in your will you have a statement that says how you want your money to be distributed. Whether or not you're going to need probate is if we have to prove up the terms of the will in order to dictate where the money goes, we generally need probate. Because how is a bank going to know whether the will that's being handed to them that says where they want all the money to go is valid? Now, There are a couple of alternative processes. One is called a small estate affidavit. So if the person who passed away has no real property that needs to be distributed at their death, and all the money in their bank accounts and financial accounts are less than $100,000, we can avoid probate and use what's called a small estate affidavit. And a small estate affidavit is when the person that you've named in your will or the successor claimant under the intestacy rules prepares a statement under penalty of perjury, and all the other heirs of the estate agree to it. A small estate affidavit can be used to gather up those funds that are less than 100,000, pay the creditors, pay expenses, and then distribute the money according to the terms of the will. And they commit to do that outside of the court system. If, however, an individual passes away and they own real property at their death, or their cash money investment assets that do not have beneficiary designations on them are total more than $100,000, we have to go to probate. I hope that answers that question. If that's not the right answer, please send in another question. Now, there is another spinoff to this, and that's called a super will. So a super will is the will that dictates what is supposed to supersede beneficiary designations. So generally, like we talked about initially, beneficiary designations are a contract between the individual who owns the money and the financial company that holds the money. The beneficiary designation will control the allocation of that asset, regardless of what the will says. That has historically always been true. A number of years ago, there was a bunch of lawsuits about beneficiary designations that were not changed or modified following a divorce, but the will was changed. And what resulted in that is this option to do a super will. And a super will, there are a number of provisions that are required for it to be valid. And at the end of the day, it really comes down to the financial institution that holds your money, whether or not they will accept the terms of the super will, or whether they're going to be dictated by the terms of the beneficiary designation. So a super will is supposed to supersede any beneficiary designation on the individual accounts. They are problematic. Generally, we always suggest that clients, if they're doing a new will that changes what their wishes are, that their beneficiary designations should change also, so that there is no ambiguity about what someone's goals are. I hope that addresses that question. Again, if not, send me another one. Andrew, is there any more on this one?
Yeah, great. Thank you. One other question, and I know so much of this is so case by case dependent, but the question is, we're a second marriage later in life. We have a will, we have a community property agreement. We also have long-term care insurance. They have accounts with us, but is there anything we're missing from an estate planning standpoint?
Oh, that's a good question. The answer is, it really is going to be case specific on what your goals are, what your concerns are, and what your assets are. So whether or not you have completed your estate plan is going to change over time. You may have, when you did this estate plan, maybe your goals were around making sure the surviving spouse has access to enough funds to stay in the home and avoid litigation from the children from the prior marriage. So there are things that your attorney would have put in your plan related to that goal. As people age, their goals may change. If there's an onset of long-term care needs, or there is cognitive decline and in-home care, or you have to relocate and you're choosing what state you want to retire, finish up your retirement years in, that can change how you want to craft your estate plan, because there are certain options and powers and tools that we may use as attorneys to help accomplish those goals that will be different than the tools that your attorney used to accomplish your prior goals. So, cliffhanger to the end of the slide, but generally you would want to have your estate plan looked at every 5 to 10 years, or if there's a shift in your goals, because the things that we put in place are related to your goals. So if those change, then usually the documents need to change to better match up with those goals. Whether or not you have everything you're going to need is going to be based on what the risks are and what your response and your quality of life goals are throughout the rest of your days. Okay, so the third document that gets prepared when you do an estate plan is a document that addresses your end of life wishes. So many times this is called an advance directive. Sometimes it's called a directive to physician. Sometimes it's called a living will. It's got lots of names, but essentially it's a document that you communicate to your medical power of attorney what your wishes are for medical intervention when you've reached a certain point in your life, whether it's due to being terminally ill, whether it's due to loss of brain activity. In Washington State, we are actually now able to do advanced directives related to dementia and other cognitive declines. So if you are faced with one of those medical conditions, what are your wishes for medical intervention? Really important to communicate in writing what those are, and communicate to the people you've named what your wishes are. Words on a piece of paper are effective, but they're not nearly as effective as a conversation supported by words on a paper about what your goals are. This is also an opportunity for people to think about who is going to advocate for what you want in this stage. Usually there are family members or friends that you can identify that will do what you want in this stage, not necessarily what the person you've named would want. So this document is worth reviewing on a periodic basis, and really worth thinking about who's the best person to name in this advocacy role. If your wishes are to, if you're passionate about what your wishes are and it may be counter to medical industry standards, then all the more important to make sure it's in your medical file, you have supportive doctors, and the people that you've named are aware of what you want them to do. Now, a lot of times clients will come in and they'll say, I have a post form that I've done with my doctor's office. Isn't that the same thing? And the answer is no. A post form stands for a physician's order on life-sustaining treatment. It was crafted to be the direction your doctor would provide if, while undergoing a certain treatment, your systems stopped performing. So think about if you're in a surgery and your heart stops. What do you want the doctor to do in that treatment, in that surgery, to resuscitate you or to not? An advanced directive is much higher. It's no matter how you got to this condition, what do you want to have happen once certain medical, certain health things have been reached? So it is more encompassing than a physician's order on life-sustaining treatment. I will tell you, though, it can be very confusing for your family members if your post form says one thing and your advanced directive says another. So generally, we would suggest that clients consider either one, having lots of conversations with their families about the difference between why did they pick this option under the post form versus the advanced directive, or two, making sure that these documents align so that there's no confusion or ambiguity about what your goals are. So the final, oh, and I'm missing my slide. The final document that gets prepared when you pass away is the disposition of remains. This is the document that clarifies what you want to have happen when your body for preparation. So if you're a cremation fan, you would want to authorize that. If you want to use, recomposting or natural burial, you would want to clarify that. And the funeral home and the other services will want to see that you have authorized for your body to be prepared in this way. If you're open to body donation, a lot of people aren't aware, but the UW has a huge body donation system for medical science. They will cremate your remains for free after you have participated in their scientific department. And then the ashes can be returned to your family. So if you're interested in that, you actually pre-process your participation ahead of your passing. And then at your passing, the UW, if they need you at that time, will come and get you. And they'll take care of your body. And then if you want, your ashes returned to your family. So we've had a lot of clients interested in this program recently. The UW also has a lot of programs related to dementia and other cognitive conditions, Parkinson's. So if you or a family member struggle with that, the UW's body donation program is a great way to increase research in that area. So how do we get this done? Well, a plug for our profession, we would always suggest the first line would be to go talk to an attorney about your estate plan. But a lot of times that can be really intimidating for clients, especially when they've not worked with an attorney before. So one of the benefits of having, this sort of service with your financial team is that, you can go talk with your financial advisors about what this is going to look like. What kind of questions are going to be involved? What kind of things are you're going to want to think about in anticipation of working with an attorney? You can always go to online services. There's forms you can get at the office supply stores. You can make your own will. We call them napkin notes. I will tell you, Washington State does not like, our court systems do not like what we call holographic wills, which are handwritten wills. They're very hard to get authorized as valid under our probate system. So, if you want to do your own will, you really want to make sure you're meeting with all the legal requirements. Otherwise, it'll just be thrown out. And it won't count as intent. A lot of people say, well, if I write it down and sign it, at least the courts will know my intent. And the answer is no. You either get a valid estate plan or you don't have one. It's very hard to take napkin notes and prove intent. The final way you can do your plan is you do nothing. And like we talked about at the beginning, the intestacy rules will control where your money goes. And the intestacy rules will control who the priority personal representatives would be to control the administration of your estate. Andrew, should I stop now before I go on? Any questions pop up?
Well, yeah, that brings up a perfect segue to a question that came in, and one that if I remember the slides correctly, will be a great segue into the next slide. How often should people be updating these? Some folks had a living trust agreement completed in 1990. How often should they be going through to review everything with all the chaos in the world going on?
Right. Good question. I think as a general mantra, having your estate planning documents looked at every 5 to 10 years is a good idea. There's changes in law, there's changes in tax limits, there's changes in family, and maybe there's changes in the people that you've named to play roles in your estate plan. So, every 5 to 10 years, take a look at that. Also, if you've had a major change in your life circumstances, people have passed away, you've inherited money, you won the lottery, you've lost a lot of money, there was an ending of a marriage, you got remarried, you had more children, you had, children passed away, those are all big life events that would really be a good time to look at your estate planning documents. With revocable living trusts, because they have a living function, when you have an older trust that you've done in like 1990 or, a ways back, you have probably shifted your assets since then. Maybe you bought another house, maybe you transferred houses, maybe you changed who custodied your money, maybe you retired and your 401k is now rolled over to an IRA. All of those things need to be tracked within your trust. So part of that trust funding is that you have to maintain your trust for the rest of your life. You have to keep it funded. What we find with older trusts is that people have neglected to maintain the funding over time. So one of the things that we would encourage people with older documents to do, especially trust documents, is to make sure your funding is updated. So even if nothing else has changed, your family, your people you've named, all are the same, it's still a good idea every 5 to 10 years to have your documents looked at, because if you're changing accounts, rolling money over from one, inheriting money, we want to make sure all those new accounts also are appropriately funded, or if you have a will-based plan, have the right beneficiary designations to make sure that your estate planning goals are maximized. Some of the other things that would really push individuals to seek professional advice is if you have any unique, more complex planning needs. Special needs planning, including disability planning for spouses, is becoming a huge talking point in our industry. There are lots of new changes in the regulation under DSHS, DDA, and some other types of bank accounts that provide for a higher quality of life for individuals struggling with either long-term care needs or special needs that are worth talking with an attorney about. If you have charitable motivations, you really want to get your estate plan done in a way that maximizes that. There's some great income tax saving mechanisms if you are charitably motivated that are worth learning about. And if you're going to make charitable donations, take advantage of both while you're alive and post-death. As I'm sure Lindsey has shared with you, there was some big changes in IRS regulations related to IRAs in the past couple of years, and that has changed the way estate planning documents need to meet with qualified funds. So if you have a lot of qualified funds and you have special goals for them, it would be another reason to have your documents looked at. If you have a taxable estate, so Washington State's tax exemption amount is just shy of $2.2 million right now. The feds currently are at around $13 million, but that number is scheduled to be decreased potentially in the future. So if you have an estate that is worth more than $2 million to $2.5 million in Washington State, that's another reason to have your documents looked at, because there's some pretty creative tools that are easy to affect that we can use as attorneys to help protect and avoid estate taxes from being applied against your estate at passing. With the changes in the DSHS regulation, there's lots of things we can do to protect spouses, both from long-term care needs as well as Medicaid liens and estate recovery. Definitely worth talking with an attorney about that specializes in that area, because the laws allow us to protect marital assets, but you have to comply with the rules. And it's very hard to fix those types of things later if you haven't done it the right way. If you have beneficiaries that are spendthrifts or don't know how to manage money, or are younger and you want to have money set aside for education or other primary legacy goals, you would want to engage with an attorney to help put together that plan. If you have people that you definitely do not want to inherit from your estate, that is also something that is quite complex, breeds a lot of litigation, and a good estate plan that's put together appropriately can really do a lot towards hedging future litigation related to disgruntled family members. So for those more complex needs, working with an attorney would be advantageous, just because the cost of fixing estate plans later can far surpass the cost of getting one done appropriately ahead of time. We talked a little bit about these needs, generally when to update your estate plan. So, Andrew, is there any other questions on this?
Nope, I think you hit it really well on the last slide.
Great, okay. So the laws are always changing. Tax rules have changed. We've talked about, the estate planning, the estate tax rules at the federal level are tentatively being adjusted in the coming years. Washington state estate tax rules have been pretty consistent, but capital gains and income tax issues are constantly in flux. Washington state power of attorney statute was changed dramatically in 2017. So if you have documents that were created pre-2017, another reason to look at them if you have the ability to redo your powers of attorney. The statute in 2017 made it so that certain powers had to be expressly provided for in your document, which means that if your agent needs to take those kinds of actions in order to protect your goals, and the power of attorney doesn't specifically provide for them, we are seeing a lot of resistance at the banks to allow for those kinds of authorities. So the more powerful your power of attorney is, the easier it is for those people you've trusted to take action that are necessary and in your best interest in the event you no longer can make your own decisions. There's been quite a number of shifts in the state Medicaid program rules. And like I alluded to a moment ago, lots of changes in the special needs disability rules that would be worthwhile learning about, providing for much higher quality of lives for individuals. Some really great improvements in those spaces in the last couple of years. So if you haven't talked with an attorney and this is a concern of yours, it would be worth another meeting at this point. Okay, so I think that brings it to a close from the slides perspective. Any other questions or concerns? I think we have a few minutes to go over those.
Yeah, a couple more questions here. What are the pros and cons to having one trustee or one successor trustee versus co-trustees?
This is a great conversation for many clients. There's a couple of things to consider from the legal perspective. If you name two people to make decisions, then we have to come up with a process that identifies how a decision is made. Is it supposed to be unanimous, meaning that everyone has to agree to everything? Or are you naming two so that both of them can act independently and they don't need unanimous decision making? If you are making it so that they are independent and they can each act, then we have to also come up with a conflict resolution solution, because if they do not agree, a bank or a financial institution does not want to be stuck in the middle of two disagreeing agents. So we have to have some conflict resolution option. So that adds complexity to your estate planning documents, but you get more transparency and accountability because there's two people that are paying attention. So depending on your family needs, that may be a good fit for your needs. Operationally, each financial institution and each medical provider has an internal policy about what they are going to interpret a joint agency relationship to require. Our documents can say one thing, but if the institution or the banking institution that you're using has a policy that is going to require or provide for another way, you want to make sure that you understand. It can be difficult. It just takes more work if you have two decision makers that are involved in the process at one time. However, if you name only a single one, then that single individual has more work to do because they're the only one who are authorized to take action. Now, many times in power of attorney and in trust documents, a power of attorney and a trustee have authority to delegate tasks. So many times we're working with our clients if we have a single agent that's named, but there's just too much work to be done by that one individual. We are creating opportunities for that one individual to delegate tasks to somebody else to help them. Yes, it works on the legal side, but we still face some resistance on the operational side, depending on what kind of financial institutions or transactions we're trying to engage in using that delegation of authority. At the end of the day, what's right is going to be what's the best fit for the family dynamics. And that is an individual decision by the family. But it's worth having a conversation with the agents to decide whether they want to be able to share the burden or whether they want to be able to have a single individual who then delegates tasks if the work becomes too much. Good question.
Perfect, thank you. And then the last question I believe that I have is a number of our clients have deep, meaningful relationships with their grandchildren. And it's really important for these grandparents to leave something for their grandkids, whether that be as a beneficiary on an account, or what would be the best way for them to go about leaving something for their grandchildren or minor children?
So for minors, you know, a minor cannot contract. So if you've said in your will or your trust, when I pass away, I want my grandchild to receive $10,000, and you say nothing more, and you pass away and that grandchild's under the age of 18, they cannot receive that money until after their age 18. So if they're a minor, that requires a court process. Some sort of custodian account will have to be opened, which can complicate the administration of the estate. Also, it means that a custodian account is going to end at age 18. Some uniform transfers to minors accounts can end at 21. But that means that these young individuals are receiving checks in what could be very large amounts at really young ages. That can impact their future access to financial funds for college. It can, engage behaviors that would not otherwise be supported because now they have their own free money. So generally, we are suggesting that families consider holding funds for any grandchild through a certain age, whether that's 22, 25, or even older, depending on the family dynamics, so that any money that's being set aside to grandchildren is going to be managed for that grandchild's benefit and can be used for certain things that the grandparents want to focus on, whether it's education, purchase of a first house, entrepreneurialism, charitable time, those funds could then be held and managed for the benefit of that individual and encourage those behaviors that the funds will support. It's not highly complex to create that kind of system that would be for the benefit of a grandchild. And what's nice about setting that up is that if any of your beneficiaries end up needing specialized monitoring, that there's terms in your estate plan that would help capture and manage the money for those, any beneficiary that would be in that situation where the money should be held and managed for their benefit. The biggest issue with that is, who do you name to manage the money for that individual for that certain period of time? There are family members, individuals, or professional trustees that could come in and manage that money according to the terms of that legacy gift. The, making lifetime gifts into educational accounts or other custodial accounts can be a good way to transfer money to grandchildren. You also get to take advantage of lifetime gifting allocations. And then when that child turns 18 or 22, they would receive that money to be used for the purposes that you've dictated. But if you don't want to make lifetime gifts and we're really doing post-death planning, sometimes we don't know what the future will bring. And if we have some provisions in your estate plan to help protect what your goals are related to those gifts to the grandchildren, then the more fruitful those funds can be managed.
Great, Jerrica, thank you so much for all the information today. I'm imagining that everyone that's listening is thinking the same thing. So many things to consider. So I want to make sure that our clients know that what should their next steps be. So first and foremost, I would encourage you to schedule a time to talk with us about your current estate plans. So we would say, great, let's review a copy of your most current will. Let's make sure it accomplishes what your goals are. I think that's what Jerrica talked about the most, that a lot of times things change over time. So we want to make sure that everything's still lining up appropriately. And then from our side of things, we want to make sure that the beneficiaries and account titles that you have on your assets with us support the planning that you've completed. And that's a really, really critical piece, because as Jerrica has said during the conversation, if it's not all aligned, then there's going to be a problem somewhere along the way. And beneficiaries, account titling can undo the best estate plans. So we want to make sure that if you've completed estate planning, that it's current, relevant, and matches everything that you have in your financial life. And if you haven't started doing estate planning yet, as I know many of you on the call have sort of been mulling, what to do, what does it look like? We want to start the conversation with you. So help you to start thinking about what is it that you ultimately want to accomplish. And then we can talk about the next steps that you need to take with a professional like Jerrica or someone else, that you want to be working with from an estate planning perspective. And I know that Jerrica has graciously offered to do a 30-minute kind of initial conversation with any of our clients who either need to review estate planning that they have in place, or just ask some simple questions to say, here's my scenario, what do I need to be thinking of? Or is there anything that I'm missing? I saw a question come in that said that specifically, is there anything I'm missing? So a lot of times we're really just trying to review what's out, what you have already, and make sure that it's comprehensive and covers everything that you need. So Jerrica, I want to thank you for your time today. I want to thank you for the offer that you're making to get that initial conversation started, so that we can better understand what are the things that clients should be thinking about, because the biggest takeaway from today is that there's a lot of considerations for each individual circumstance. So we really just want to make sure that everyone's plans are aligned with what their specific needs are. And then, as I mentioned, for our clients that work with us, we also want to assist you in that process to make sure that at the end of the day, you have high confidence in the planning that you have in place. And then that helps to give you greater peace of mind. So thank you all. I know we went a few minutes over, but really appreciate you joining. We have recent webinars that we did on Social Security, tax planning. You can find those recordings on our events page. And then we are going to have one coming up in the fall on Medicare and long-term care. So keep letting us know what topics are of interest to you, and we'll keep providing what I hope is extremely beneficial information. With that, we'll let you go and have a great afternoon. Thank you, Jerrica. Thank you, Andrew. And thank you for joined.